Hello, this is Chris Jackman. Welcome back to the Chris Jackman Show in 2025. Looking forward to talking to you this year about a new topic and a new area that we're getting into to help our clients because we've seen over the past few years this is becoming a reoccurring problem. And what we're seeing a lot of times is that when we finish with a family law case, especially representing a father who's gone through a divorce or some kind of custody battle, what we're seeing time and time again is that they're not updating specific and critical legal documents. And it's coming back to bite them potentially. So what do I mean by that? Well, number one, I'm talking about life insurance policies. As you can imagine, a lot of our clients have life insurance through their work. And, when they go through a divorce, they are forgetting then to go back and update the life insurance policy to change what's called the beneficiary. And that's just the person who stands to get the money, God forbid, when you pass away, right? So most people just, when they're going through when they're getting married or dating, a lot of times they'll list their spouse or their girlfriend as the person who stands to inherit the money. This is called the beneficiary. And most life insurance policies are $1 million or $3 or sometimes $5 million. So we're talking about a lot of money here that's at stake, and years go by and people forget about it, right? So that was one thing that led us to do it. The other thing was just the obvious, which is people not updating their will. Some people have wills. I think I read the other day like 60% of Americans don't have a will. Of the 40% of people that we see who do have a will, they aren't going back and updating that will after they get divorced or after they go through a family law case. And what they don't realize is that if they don't update that will, and when something happens, whether they pass away or become incapacitated or whatever it may be, whoever's listed in the will is the one who's going to inherit or get whatever the person mentioned in the will, which, again, when you go through a divorce, you typically are cutting out someone from your life, and you don't want that person getting your kids, your house, or your retirement or whatever. So we just found over time that it just makes total sense to start branching off and doing more and more estate planning. And the more I got into it, the more that I saw, the more that I want to help people in this area, because I see that there's a huge demand for this. And I think a lot of people have not gotten any advice at all. And if they've gotten some advice, it's bad advice. And so the topic of today is the worst advice I see people get and how we can fix it. And as we go through this year and the years to come, I'm sure I'll give you a lot more information on this area because there's a lot to get to in it. But the number one thing I want to discuss today is why having a will alone is not enough to protect your children, protect your assets, your home, your retirement account, any of those things. Because I think that's kind of a common misconception that people have, is they think if they just have a will, or God forbid, they get online on some of these websites like LegalZoom or Rocket Lawyer, there's even books you can buy, and that's going to somehow be sufficient. And there's a really important reason why it's just not sufficient. And the reason is that, with a will, you're not going to avoid or get around something called probate. You might have heard that term, probate court or going to probate. And a lot of times people don't stop and ask, well, what is probate and why is it something that you want to avoid? All probate is just a court system that you go through whether you either have a will or you don't have a will. If you do have a will, you go through the probate system to make sure that will is actually correct. It's actually valid, because there's a lot of steps and there's a lot of things you have to do to make sure that will is actually going to be certified or approved by the state. Every state has their own unique rules as to what makes a will valid, but just writing on the back of a napkin or getting on Rocket Lawyer or whatever, and putting something together often isn't enough. And so that's part of the process, right? Is if you have a will, you have to go through this court system called probate. And there's a lot of downfalls to it, right? There's a lot of things you don't want to do or you want to avoid. And court is one of them, right? People don't realize that almost universally, no matter what you're doing, you don't want to be in court. Number one, it's expensive because chances are, if you're going through this probate system, you don't want to do it alone. You probably want to have a lawyer with you. And as you can probably imagine, paying a lawyer by the hour or even paying some flat fee, it's never going to be $100 or $500. It's going to be more like $5,000 or $10,000, right? Maybe more. So, it's just, you don't want to be in court. It's expensive. Number two is it takes forever. I've been in and out of courtrooms now representing folks for over a dozen years, doing litigation primarily. And I can tell you that there's been a steady trend and over those dozen years to things taking longer and longer and longer to get wrapped up in court. And I think it's just a supply and demand issue where there's an increasing demand of cases and a limited supply of judges and of courtrooms to hear all of these cases, right? Just the way it is. Every state, again, is unique and everyone's case is unique, but I rarely see a probate case get wrapped up in under 6 months. And in some cases, in some areas, that could be like lightning speed, right? It could very well take 2 or 3 years, in some cases. I remember reading a couple of years ago about Prince, the famous musician, and he died without any kind of will. So it's a little different than we're talking about here. But, his case was going on for years, like 3 or 4 years through the probate system. And his relatives were spending like hundreds of thousands of dollars, like fighting with each other over this lack of will. Because I guess Prince had like a $200 million of an estate left. So, you could imagine folks were incentivized to fight it out. But again, even if you have a will, you're going to go through the probate system. And, it's not going to get wrapped up quickly. So number one, you want to avoid probate because it's expensive. You're probably going to have to hire a lawyer because chances are, if you're like most folks, you're busy with your career, with your family, with your friends, your hobbies, and trying to find the time to research how to figure out the proper court forms and where to file them and when to go to court and what to say is going to be completely beyond your pay grade and over your head. And so you're probably going to need a lawyer to help you through it. And that's not cheap, right? And then second, it's expensive, and it's time consuming, right? So those are the reasons why you want to avoid probate. Another reason why you want to avoid probate too is people don't realize that, if you're putting your will into the court system, it is a public document, right? And years ago I'd hear that and I would think, well, who's going to take the time and probably has the know-how, even though it's not brain surgery, to figure out how to get into the court docket, and why would you want to research this stuff online, right? What is that going to benefit someone? And what I found over the years from talking to folks is that it's kind of becoming a breeding ground for house flippers. Not disparaging or talking bad about that profession. I've got friends who do it, but that's one of the ways these house flippers find homes. And I can tell you, they are really aggressive, these house flippers, once they get a hold of your information. Because if you think about it, if you're a house flipper, a home that's in probate is probably like your ideal home, right? Because if you're a house flipper, you're looking for a home that probably hasn't been updated, that's in a good area and that needs some work. And most importantly, you're looking for distressed sellers, right? You're looking for folks who really, really want to get rid of their house. And very few people want to get rid of their house more than the son or daughter or whatever the relative is who inherits a house they don't even want. Right? As you can imagine, if mom dies or dad dies in their 90s and they got a home that hasn't been renovated in 30 years, the son or daughter don't want to take that mortgage on. They don't want to take the property taxes on. So they're motivated to get rid of that house quickly, right? And again, that is a prime home and a prime target for house flippers, because nowadays most courts have finally caught up with the times. And they have online, dockets that you can search, right? So, a house flipper could be living in, Bali, or China or wherever, and find your home if you're living in Houston or living in Denver or wherever. And then normally what they do is they do a pretty targeted, or I should say very targeted and very aggressive campaign. They will call you, they will send mailers. If your email is listed in the court documents on the probate system, they'll email you. They will do everything they can to try to get you to sell. So it's one of those things where, we all get spam texts and calls from folks, and certainly spam and junk mail, but it's just one more thing you've got to have on your plate that you could completely avoid if you use something other than a will. And number three is obviously probably what you've seen on TV is in the movies is sometimes wills are fought over, right? Because sometimes the will isn't super clear. Sometimes you just get someone who's been left out of the will, or the will tends to leave a lot more money or assets to one person or the other in the family. And next thing you know, the family breaks out in this huge fight. And there's this argument as to what the person really meant to say when they wrote the will, or what they actually really wanted, the daughter to get or the son to get that wasn't in the will. And suddenly you have what's called a will contest, what I call a will fight. And now you've got family members fighting each other over the will. And again, it's right back to my first point. You end up in court, it's expensive. You end up in court, it takes forever. And in this instance, do you really want to be fighting with your siblings or relatives in the courtroom over what a will said or didn't say? And again, all the time I read wills that aren't super clear, and wills that frankly may not be fair to some members of the family, and boom, you've got yourself basically a lawsuit that goes on between family members over this will. So, those are the three main reasons why I'm not a big proponent of just doing a will. Now, I will say this. If you're on your deathbed, although there could be some issues with that, but if you're hurried and you just need to get something done, obviously having a will is better than having nothing at all. But I don't want to sit here and tell you that just having a will is enough, or that having a will is the right way to go. Because it's not, for the reasons I gave. Number one, it's expensive. You're hiring lawyers. It's going to take forever. Two, it is not public. Everybody could look this up all over the world now because they can log in remotely to these courtrooms and see what's going on. And number three, like I said, you've got the real possibility of a fight breaking out over the terms of the will, over what the will does or doesn't say. And so those are the three, I would say, primary reasons why I caution people on just having a will, right? Now, again, it's better than nothing, and you definitely want to update it if that's all you have after you go through a family law issue like we're seeing time and again. But really what you want to do is you want to have a trust. And years ago when I was in law school, I frankly kind of tuned this stuff out because I used to think that trusts, were only for the super rich. You always hear trust fund kids and that sort of thing. And I just kind of dismissed it because I thought, well, I don't know any super rich people. I'm not a trust fund kid. And so I didn't really delve into it too deeply, to be honest with you, when I was in school. It was only years later, like I mentioned, when we started dealing with a lot of family law issues and fathers who were going through issues that we realized pretty quickly that the trust is the proper tool or mechanism to help folks, and it's not, to be clear, it is not just reserved for like the super, super rich, right? Anybody could have a trust, and it's not super difficult to set up. Now, for purposes of this initial podcast, I'm not going to get into every single kind of trust and every nuance and wrinkle that you can do with the trust because it is really extensive. It can get really complicated in terms of what the trust can do, and it can do a lot. It can do a lot more than a will can. The trust can in fact, as you might have heard, shelter money from taxes, from creditors. If you get into some of the really exotic stuff, which I don't pretend to be an expert in, and frankly maybe borderline illegal, which obviously I don't delve in and know much about. But you hear about trusts in the Caribbean, right, and Liechtenstein, and all these foreign countries that have different laws with respect to trusts and sheltering assets. And that's not what we're going to get into, and not what I'm advising anybody to do. But just be aware that certainly there are things you can do with trusts that are very complicated and do kind of conform, to the stereotype that trusts are for the rich and that they're intended to shelter things and in some cases probably hide things. But that's not what I'm intending to talk to you today about. It's not my niche by any means. My niche really is finding solutions for the vast majority of people. And that's definitely, like I said, a trust. And the technical term for the trust that I recommend for probably 90% of my clients is just called a revocable living trust or a living trust or a revocable trust. One of the confusing things about this area of law is that there's a lot of different terminology for the same thing, but we're really talking about trust that you can control, right? And so what are the benefits of a trust and why should you do it? Well, it's kind of just the inverse of the things I told you about with a will, right? With the trust, it avoids probate, right? You don't have to go into the court. If you set up the trust correctly and everyone's on the same page about what it means, which they should be if a lawyer drafts it, it's almost like things carry on as usual, even though someone has obviously passed away. So it's not like you have to probate your trust, right? That actually that's not even a thing. It doesn't even exist. So you don't probate your trust. Your trust just takes effect, right? So that's number one, is you're avoiding, all of the costs and all of the stress and the time that goes into having to go through probate. Number two is you're keeping it private. Right. Remember what I mentioned a moment ago with wills is that, it's all a public document, right? So anybody over the world can log into the court system and look at your will and see what it says, but no one can see your trust, right? Your trust is a private document. It does not, I repeat, it does not get filed with the court. In fact, the only people who should probably see the trust is the trustee, which could be you if it's a revocable living trust, could be someone else, if you trust them enough. And then you might share it with a beneficiary, people that you're leaving stuff to so they know where it is and what it says. But other than that, nobody's going to see this document. And obviously, if you have a lawyer draft it, your lawyer will see it. But the trust is the way to go because it keeps it private. And number three, is it possible that, you could set up a trust that gets contested? I guess normally the answer is no. You can't contest a trust, and you can even have language, in the trust, and you could have the same language in a will too. By the way, just saying it cannot be fought over, it cannot be contested. Now, the only thing with trust that you got to be a little bit careful of is that there is the possibility that you could have a trustee, which again, the trustee is the person and basically in charge, right, of distributing assets and just doing what you want done with your estate, right? So it's possible, that you may appoint the wrong person. Maybe God forbid you appoint a son or a daughter who kind of goes off the reservation, so to speak, and starts doing stuff that isn't laid out in the trust. But here's the thing about that is that person could be held liable, at least civilly liable for what they're doing, right? So they've got some guardrails in place to prevent them from doing anything other than what the trust says, right? So just be aware of that it's going to be almost impossible, right, to contest a trust, to have people fight over it, right? So it's just, it avoids the three things that the will in most instances doesn't avoid, right? It avoids all of the legal fees you're going to incur, being in court. It's going to avoid all of the time that you're in court. It's going to avoid, having everything in your will become public that anybody and everybody can read. And like I said, in all likelihood, it is not going to be something that leads to a huge fight with your family members the way that a will does. So now there is something I'll mention about a will. I often draft for my clients what's called a pour over will. So even if we do a trust, and like I said, 100% of the time I recommend that. But even when we do, we do a trust, I always recommend that we do what's called a pour over will. And it's a pretty simple document. It's not nearly as extensive as a full-blown will. All the pour over will say effectively is like, hey, if I pick up any assets, house, retirement accounts, anything that I don't have listed right now in my trust, I want to go into my trust. Why do that? Well, in theory, you could update your trust all the time, right? To accommodate and to list out all of the things that you pick up over time. Right? Because if you do a will, let's say in January, and then in June, you buy a second home, or you open up another brokerage account, or, I mean, you could think of all the things that you pick up along the way, a rare art, right? Or a piece of art that you love, right? If you're having to update your trust like every 6 to 12 or 6 to 18 months, it can be a lot. I'm not saying that you shouldn't update your trust. You certainly can. We do it all the time for folks. But a way to avoid that, even though, again, I do recommend updating your trust for very major life events, such as a home, is to have that pour over will. So that way, the idea of the pour over will is it's like a catch-all mechanism for things that you forgot to list in your trust, or, like I said, that have come up after the date that you actually do your trust and sign it. So that way it isn't excluded, right? So just to be crystal clear about this, if in fact you do pick up a major asset after your trust is drafted, like a second home, maybe you get a vacation home, right? Or maybe you get a timeshare, or maybe you fund some brokerage account with a lot of money from a raise that you got. I would absolutely recommend in that case going back and updating your trust. I can't speak for every lawyer, but I think most law firms are like us in the sense that we'll charge a very modest fee to go back and do an update, just because we're happy to do it for our clients. We want to see them and stay in touch with them. And so, we're not going to charge much at all to do a minor modification like that. But I'm just saying, as a backup option, it's good to have the pour over will, because again, if you forget to go back to your lawyer's office and update your trust, and you have picked up something that's of value, this is kind of your backup option. And it's going to make sure that if you forget, like I said, to put the second home or the brokerage account that you've since gotten since your trust was created, if you don't have that pour over will, there's a chance that asset, the home or whatever it may be, goes through probate, right? And that's something else I failed to mention that I should have mentioned a bit ago, is that with probate too, property in different states has to be probated in that state. Trust doesn't. So in theory, you could have a home in every single state. And again, if you have a trust that contemplates or discusses these properties, you're good. You don't have to go through probate. It's in the trust. But if you just have a will and you have property in 50 different states, or if you're like some folks and maybe you've got a winter home in Florida or Arizona or whatever, then you have to go through a separate probate in that state. And so that means hiring a different lawyer who's licensed in that state to represent you and going through the whole process all over again. So, it's almost like you're getting double probated, right? If you have two homes or you have properties or even land, right? Same idea. If you have land or a farm or, anything, and maybe you inherit a childhood home, in a different state. In all of those cases I gave you, you have to go through probate in that state, right? Whereas with a trust, you don't have to do that. It's all in the trust. And it's sort of irrespective of state, so to speak. So, again, that's why, to finish my thought from a moment ago, we always recommend, having that pour over will, so it encapsulates and it captures the things that have come up in your life since you last did your trust. Hope this has been of help to you. Obviously, I just wanted to give you an introduction to something that's been on my mind and I'm going to be talking to you a lot about in 2025, finding some strategies that I hope make your life better, that save you money, protect your kids, your house, your assets. In the next episode, we're going to be talking about kids and how the right kind of estate plan can help kids. But for today, I just want to talk about the benefits of why a trust is infinitely better than just having a will or nothing at all. And look forward to talking to you in the next episode.